course of the past year, various tax legislations and decisions have been issued by the United Arab Emirates, one of which is the Tax Procedures Law. And what the Tax Procedures Law does, amongst other things, is it sets out the stages that a taxable person goes through when challenging a tax assessment by the Federal Tax Authority. And the first stage in that challenge is requesting the tax authority to reconsider a tax assessment, and the authority has 20 working days to respond on that request for reconsideration, after which the second stage is to object before the Tax Dispute Resolutions Committee. And the committee has 20 working days to decide and 5 working days to communicate their decision to the objector, the taxable person. Stage 3, if the taxable person wants to challenge the committee's decision, is to file a case before the competent court. The law doesn't define what the competent court means, but given that the tax authority is an administrative body representing the government and collecting dues from the taxable person as the debtor and the state as the creditor, it is an administrative body, and this relationship between the taxable person and the federal tax authority is an administrative relationship, hence subject to the administrative circuit of the federal court. But what occurs when the committee has not been formed yet? The United Arab Emirates has issued a decision to form a committee in Dubai and Abu Dhabi, but the names of the members of those committees have not been published yet, hence the formation has not been perfected. And in this case, we look at precedent to guide us in such situations. And given that we are a civil law jurisdiction, not a common law jurisdiction, case precedent does not play as big of a role as it does in common law jurisdictions, but it guides us and it helps guide the courts and judges and create a palatable narrative for the judges to hear matters. So for this particular situation, we look at one case number 674 of 2008, Federal Supreme Court decision. At the time, the courts were subject to a legislation that required the formation of committees for arbitration and conciliation within the federal courts, and claimants had to submit their claim to the committee first and subsequently file a motion before the courts. This particular claimant had grieved before a court where the committee was not formed yet, and hence filed their motion directly before the judge, the competent judge. The judge dismissed the motion, given that the claimant had not proceeded to the committee first, and the matter was escalated to the Federal Supreme Court. And the Federal Supreme Court found that in light of the minister not having formed the committee yet, the claimant had the right to submit their plea to the court directly. And this gives us guidance with respect to current taxable persons who want to object to the federal tax authority's reconsideration, and in light of no committee being present and so forth, there are avenues where rights can be preserved.